Hey gang, Stephen Marshall, KYLandlordlaw.com, back with two announcements and a fair housing update today. Both announcements are for my Fayette County folks. So if you're non-Fayette County, you may not want to listen to this, although the announcements could be coming to your area sooner rather than later. The first is that all jury trials in Fayette County have been postponed until February. So if you had a jury trial in an eviction case or any type of case scheduled for November, December, or January, those cases have all been postponed until February at the earliest. You'll get a new court date on those. Second, and this is going to be very interesting to see it play out. No in-person evictions during the month of November in Fayette County. All evictions in Fayette County during November will be done remotely. So if you have an eviction scheduled this month, here's your instruction. You are to contact the Fayette District Court Judge's Office at 859-246-2247 within 1 hour prior to your court date, to your hearing. And they will give you instructions on how to appear remotely. Now, if you use an attorney to file your case, your attorney will get those instructions for you. Typically what that means is they just will give you a Zoom link for you to appear via Zoom, and that's really been working out well so far. But here's an interesting part of the order. Any party that cannot participate in a remote hearing due to limitations in technology will have their court case continued for 1 month. So I guess the good news, the silver lining, is that the courts are not shutting down like they did last spring. They're just going to remote proceedings entirely, but this is probably going to delay things just a bit. But as always, we'll see how things play out and we'll make our adjustments. So no in-person evictions during Fayette County during the month of November. That's just November only. Now that deadline could get extended as things keep going. It'll depend on how the COVID numbers continue to shape up, but for now it's just the month of November. So no jury trials until February. All evictions will be by a remote proceeding during the month of November in Fayette County in both cases. Now, we have diverted our attention for most of 2020 to these eviction moratoria, both statewide and throughout the country. But HUD has continued to file housing discrimination lawsuits against rental owners and managers who, in their view, cross the line on fair housing issues. And I try to keep up with those. And during the month of October, HUD announced several new cases that it has filed that should serve as good reminders to us about best practices. And I'm going to highlight one in particular because it's instructive during this time when lots of folks are considering non-renewing leases as a workaround to the eviction moratorium. So the case I want to talk about is HUD versus Labonte, and it's an assistance animal case. This property that's at issue had a no pet policy, and several months into the tenancy, the tenant notified the manager that he was considering getting an assistance dog to help him deal with physical and emotional issues. Now, in response, and this was through text message, the manager told the tenant she didn't want pets in the property, and she asked him to wait until his lease expired before getting the dog. She then offered, and this is kind of interesting, she offered to allow him to use her daughter's dog, which actually lived at a different property, and then told him he probably needed to look for alternative housing in the meantime. The tenant on his end ultimately provides a letter to the manager from his doctor stating that he needed the dog due to his disability. Once she got that, the manager responded that, well, the dog is going to need to be trained and certified, and you're going to have to pay a deposit. Okay, hopefully you guys are seeing lots of things being done wrong here. The tenant then made a formal written request for permission to have the dog without any training or without any charges to him. The manager never responded to the letter. So about a month after sending the letter, the tenant gets the dog anyway. The manager doesn't take much further action, but 2 months before the lease was supposed to end, the manager gives notice to the tenant that she is not going to renew the lease when it expires, and she began attempting to re-rent the unit. Ultimately, 30 days before the lease ends, the manager gives the tenant notice that he needs to move out when his lease expired because the unit had been re-rented. So after the tenancy, HUD files a lawsuit on the tenant's behalf, seeking that the landlord pay the tenant for his actual damages, which they included to be lost housing opportunity, physical and emotional distress, embarrassment and humiliation, as well as seeking a civil penalty of $16,000 against the manager for each violation of the Fair Housing Act. And you can read HUD's full complaint. I'm going to stick it in the as a link in the blog post that accompanies this video. Now, this is just HUD's complaint, okay? It's just their side of the story. And so we know that there are two sides to every story, and so the manager may not have done things as poorly as she seems to have. And from the manager's actions, we can find lots of lessons to learn and how not to do things, but there are two big picture lessons that I think are timely for us. First, fair housing violations can be very, very costly. The landlord in this case is going to pay 5 figures just to deal with this case. If she loses, she'll end up paying 6 figures. Okay, that makes erring on the side of caution when you're terminating a tenancy very important, because I've said it 100 times, defending fair housing cases is expensive. Even if you win, even if it's a frivolous case, it's going to cost you money to defend. But cases that have merit, cases that are close calls, those will cost you a lot of money, and that one is probably going to be a 6-figure case for the landlord. Second lesson to learn, and this is very important these days, the defense of I'm not going to renew your lease and I don't have to give you a reason is very risky, especially if you have a case where a tenant has been asserting their rights throughout the tenancy. Because if HUD feels that you didn't renew that lease for a discriminatory reason or in retaliation against the tenant for them asserting legitimate rights, they're going to file a housing discrimination complaint against you. So when you're faced with those situations of non-renewing leases, be very cautious, and you probably need to reach out to your friendly neighborhood attorney to help you with that. So, short and sweet today. I won't be seeing you guys in court this month, so be sure to reach out to me if you need me. Shoot me an email, smarshall@trippleslaw.com. Hope you're doing well. Take care.